Welcome to County Portal, your simple source for local government services and public records. Let's get started.
Obtaining the medical records of a deceased relative is a necessary but often confusing task, especially when you're already dealing with a loss. The main reason this process can be challenging is a federal law called HIPAA, the Health Insurance Portability and Accountability Act. HIPAA is designed to protect a person's private health information, and those privacy rights don't just disappear when someone passes away. So, how do you navigate this? The key lies in understanding who has the legal right to access these records. The primary person with this right is called the personal representative of the deceased's estate. This is usually the executor or administrator named in the will or appointed by a court. If you are the personal representative, you have the same rights to access the records as the deceased person would have had when they were alive. To start the process, you'll need to follow a few key steps. First, you must gather your documentation. You will absolutely need a copy of the death certificate. Next, you'll need proof of your identity, like a driver's license. Most importantly, you need to provide legal proof that you are the personal representative. This crucial document is typically called Letters Testamentary or Letters of Administration, which you get from the probate court. Once you have these papers, contact the Medical Records Department, sometimes called Health Information Management, of the hospital or doctor's office where your relative received care. Don't just call, you will need to submit a formal written request. Most healthcare providers have a specific form, often titled Authorization for Release of Information, that you'll need to fill out. You'll have to state your relationship to the deceased and provide copies of all your legal documents. Be prepared for a waiting period, as it can take several weeks, and there may be a small fee for copying the records. Now, what if you're a family member but not the personal representative? HIPAA does allow providers to share relevant information with family members who are involved in the deceased's care or payment for care, unless the deceased had previously expressed a wish for that information not to be shared. For example, if you helped manage your mother's diabetes treatment, you might be able to get records related to that specific condition. However, you likely won't be granted access to her entire medical history. It's also important to know that HIPAA's privacy protections expire 50 years after a person's death. After that point, the records are no longer protected by this law and are much easier to access. If your request is denied, it's usually because you haven't provided sufficient proof of your legal authority. Double-check your paperwork and resubmit, or if the records are vital for a legal case, you may need to consult an attorney. Thank you so much for watching. We hope this guide provided some clarity during a difficult time. If you found this information helpful, please give this video a thumbs up and consider subscribing.